And Carissa, he made the choice. He got the choice between jury and judge and decided on jury. I guess when you're in his position, you know, there's sort of like what's worse question, right?
Well, I don't think that this guy has very good judgment.
In general.
Right. First, the crimes that he was found guilty of. And then he takes the stand in his own defense, which ended up making the case worse for him. And now he's allowing a jury to decide his sentencing rather than a judge that may be able to understand mitigating factors.
Well, Carissa, like, again, the idea that we're talking now about the sentencing phase, which happened last night, this is just more evidence against him.
It is more evidence against him, like his mother said in another recording earlier, which was played earlier on the network. He can't get out of his own way because he can't just stop talking. And he took the stand in his own defense, and he keeps talking, and now he wants the jury to decide for him. He thinks he can defend himself, but everything he says makes it worse.
And offends the jury.
And he thinks he can smooth talk the jury. That's what he's thinking. He's important, right, Carissa?
Right. You know, the jury needs to understand, in this case, the difference of and how to interpret a will. But I think, you know, I know we're running out of time and going to break, but it really isn't looking good for the prosecution.
No. Got it.
I also think because it's a sentencing phase, there's always a score sheet that's considered, which is aggravating and mitigating factors. So they're going to take into consideration all his previous history in order to come up with a sentence that they think is appropriate based on the crime.
Yeah, I mean, in the context of a sentencing hearing, you're allowed to say, you know, the guy was a Boy Scout, he was such a wonderful boy, and this and this. So why shouldn't you be able to also say the guy was a horrible person?
But they're allowed to bring in all this evidence to evaluate him and his character. The standard is much lower. Even in sentencing hearings, hearsay is allowed, whereas in a normal trial, hearsay is not allowed. I think they're trying to prove motive, and the only way they're going to prove motive, because this case has reasonable doubt all over it, is by confusing the jury, by calling all these witnesses.
We like that.
That's the only way to win this one on these charges. You have to confuse the jury because they're just going to be there arguing and saying, well, this doesn't make sense and this doesn't make sense. And if they bring in 90 witnesses to testify, they're going to say, well, they must have a case because 90 people are testifying for the prosecution. You know, but if they listen, they're going to see, well, it doesn't make sense. It just depends who is the panel of jurors.
I'd like to sum up. I'm going to kill
real quick, Chris. Yeah.
No, when I was a prosecutor and I would do voir dire with jury selection, if you asked a jury, would you rather let a guilty man walk free or put an innocent man behind bars? Unanimously, everyone would say they would rather let a guilty man walk free than someone innocent go behind bars. In this case, there's reasonable doubt all over
Let's take it. Is unusual.
And it'll glean some insight on where the jury is going because this is so confusing. It'll be interesting to see what kind of question the jurors ask because that will implicate whether or not they think maybe he's guilty, maybe he's not guilty, and are they really understanding and parsing through all the evidence and all these witnesses and all these really technical legal terms.
Right, and what are they focusing on? Meaning, are they focusing on this idea that there could have...
The other question is jury retention. Does the jury remember that earlier last week that Tex McIver's salary was $250,000? It already, from what we just heard on this witness, her salary was less than his.
Yeah,
so combined,
the tax issues, who wants that?
The prosecution's case for motive isn't. I think they're failing at meeting their burden. They're not meeting their burden.
As we hear that, Carissa Kranz, you were named by American Society of Legal Adversaries or something 40 under 40. So if you are that big a deal lawyer, you explain to me what the prosecution is doing here.
The prosecution is just confusing the jury right now.
On purpose?
And they're focusing on the money and the money and the money, but what about the emotion of Mr. McIver? He lost his wife. Maybe he wants to go back to work because he doesn't want to wallow in his own sorrow of what happens and he wants to get busy. Maybe, but you know, he also wants a certain number to go back to work because it has to be worth it for him to grind those hours out. But it may not be about money. It might be just him wanting to be busy and not you know, realizing that he's now alone in his 70s for the rest of his life and that he lost the woman he loved.
Let's do this.
That's what she's saying, but if you think about it logically, I think it lends some doubt into her testimony if that's possible. If you're just shot in the back, do you really have the range of motion to swing around and turn to the back seat and say, hey, I think you just shot me? Also, if you watched the video last week when she was taken out of the car, she was practically paralyzed. You know, they had to lift her out, lift her legs. I'm not sure she really had the range of motion. If I were a defense attorney, I would point to the fact that she's trying to reenact, and in her reenaction, she's literally leaning to the person in the passenger seat as if that is his wife and showing her swing around, which I think lends doubt.
Come right back with live testimony.